The committee will come to order, and first of all, let me begin by thanking all of you for joining us this afternoon to discuss the continuing crisis of international parental child abduction and how the Trump administration can and must use current law, especially the tools embedded in the Goldman Act, to more aggressively bring children home to their families. I especially want to thank the brave left-behind parents in this room and hundreds of others who are here in spirit for tenaciously struggling to recover their child or children from an abduction. The deleterious physical and psychological impact on abducted children, including parental alienation, coupled with the pain and agony endured by a left-behind parent from a forced, illegal, and inhumane abduction, demands more effective U.S. government action. Today, we will hear from three extraordinary parents who have left no stone unturned in the noble quest of bringing their kids home. Out of deep love and concern for the safety and well-being of their children, all three parents, Jeffrey Morehouse, Juan Gariosia, and Michelle Littleton, continue to strive and to hope and to believe. All three parents and far too many others like them, daily endure the absolute nightmare of having had their beloved children kidnapped and taken to a foreign land. We can and we must do better. As Jeffrey Morehouse notes in his testimony, to date there have been more than 400 U.S. children kidnapped to Japan since 1994. To date, the government of Japan has not returned a single American child to an American parent. He notes that last time that he hugged his son, the last time I heard his voice was Father's Day 2010. I love you, Moki, wherever you are, he said. Our kidnapped children's true voices, he goes on, have been silenced, and he speaks on behalf of many other left-behind parents, and that they need to be heard. Child abduction is child abuse, and it continues to plague thousands of families across the United States. Each year, more than 450 new children are abducted, adding to the 11,000 children who were abducted internationally between 2008 and 2017. The good news, since Congress adopted legislation that I wrote in 2014, the Sean and David Goldman International Child Abduction Prevention and Return Act, Public Law 113-150, we have seen a huge reduction in the number of new abductions each year. In fact, 450 is half the number of just 10 years ago. According to the State Department's annual report on international child abductions for 2018, the State Department's prevention team has been working with the Department of Homeland Security, as directed by the Goldman Act, to protect vulnerable children from abduction. Last year, 210 very high-risk children were enrolled in the DHS prevention program, an increase of 60% over 2016. We have also seen some high-profile federal criminal prosecutions of taking parents and their accomplices, such as the prosecution and conviction of Carlos and his wife, Guimarães, for assisting in the kidnapping of their grandson, Nico Bron, to Brazil 5 years ago. These prosecution efforts of the DOJ and FBI are incredibly important, not only for holding the perpetrators accountable and for driving home the seriousness of international child abduction, but also for deterring future abductions. Ask anyone who works in the field or any left-behind parent, and they will tell you that international child abductions are very difficult to resolve, even with the 77 countries that have partnered with the United States in the Hague Convention on the Civil Aspects of International Child Abduction. 215 children came home last year. Every return is a hard-won celebration and should not be minimized. But every case resolved without return must be scrutinized, and aggressively so. 197 cases were closed without return. Did the parent agree to let the child stay abroad because they could not afford the financial or emotional cost of fighting in a foreign court for years on end? Did the foreign court expansively read the Hague Convention exceptions to return so that living in an apartment counted as a, quote, grave risk of harm, such as Japan's courts held in the Cook family case, which is absurd? The Hague Convention was intended to minimize trauma to children and left-behind parents, returning children to their home country for custody determinations and to do so quickly. But it is regularly flouted without consequence to the violating country. Tragically, the State Department has persistently refused, and this is the bad news, persistently refused the use of return tools that are in the Goldman Act, as envisioned by Congress, to enforce the Hague Convention in both Hague and non-Hague countries, and to move non-Hague countries to bilateral resolution agreements with the United States. A 42% turn rate of American children within 2 years of abduction, and that's the rate, cries out for immediate and systemic improvement. We can and we must do better. The Goldman Act, of course, empowers the Secretary of State with significant sanctions, including the authority to withdraw, limit, or suspend U.S. development, security, or economic support assistance, to delay or cancel one or more bilateral working official or state visits, to extradite the taking parent, which puts pressure on the parents to return the child, to come up with their own actions that would have a positive effect, and many other prescribed actions that are in the Goldman Act. To my knowledge, extradition has been used once, and the other options, not at all. That has got to change. At a Senate hearing on April 24th of this year, Assistant Secretary of the Bureau of Consular Affairs, Carl Risch, testified that the State Department, quote, considers all the tools the Goldman Act provides for the most effective way to make progress with particular countries. However, more than 2,000 cases after the Goldman Act was signed into law, the State Department has apparently never found a single case where those tools would be helpful, not even in the cases where the foreign courts had decided on return, but just failed to enforce those orders. Devin Davenport has won all 24 appeals over the last 9 years for the return of his daughter Nadia from Brazil, and yet she is still not home. Dr. Braun has been waiting for 5 years for the return of his son, Nico, from Brazil. We have 100 American children abducted to India with almost no hope of return without the United States choosing to take real action. And again, those actions are in our law. They're in the Goldman Act. Use them, Mr. President. We could also lower the number of visas available to Indian citizens until abducted children are returned. Another opportunity to get this right. While Japan was finally named a non-compliant country by the Trump administration in this year's annual report, after having just about nothing done in the previous administration on Japan, Japan is still not held accountable for the dozens of cases that were pending before it signed the Hague Convention in 2014. And Jeffrey will talk about that in his testimony. But what a dark day that was. They signed the Hague Convention, which maybe opens up the door to some cases from then on. But all the cases that preceded ratification of the Hague Convention are grandfathered out. What a gross injustice. Marine Corps Sergeant Michael Elias suffered the abduction of his two children in Japan in 2008 after courts in New Jersey decreed shared custody and no travel for the children. Japan gave the children replacement passports to facilitate the abduction. Sergeant Elias has not been able to speak to his children in 10 years. I actually traveled with my chief of staff to Japan to raise his and other cases, and I was shocked, frankly, about what we were not doing to help this combat war veteran at least see his children and hopefully to bring his children home. I believe the Trump administration can and must do better with the backing of the Hague Convention, bilateral agreements, and requests for cooperation in the return of abducted children, and with the actions described in the Goldman Act. We can and we must do better. The time is now. Delay is denial. And for these three parents and so many others like them, the agony is every day, and then every day. And we need to change that, and we can change it with our law. I'd like to yield. Who was here first? Mr. Garrett, for such time as he may consume.
Thank you, Mr. Chairman. I'm going to waive and reserve time later.
Okay, thank you very much. I'd like to now yield to the gentleman, Mr. Posey.
Thank you very much, Chairman Smith, for recognizing the problem that we have today and for holding this important hearing and for allowing me to join you in your discussion and your questions. I'm proud to represent Michelle Littlejohn and one of the three witnesses here today. Ms. Littlejohn's three children, beautiful children, 2 daughters and a son, Asila, Lila, and Yosef, were tragically abducted by her former husband to Lebanon nearly 2 years ago. She's worked tirelessly to litigate their return in Lebanese courts and has won remarkable landmark decisions that have essentially established her case to return the children. Yet she waits. I must defer to her with great respect to tell you the entire story and commend her for her brave struggle. Mrs. Littleton's testimony and that of the other witnesses here today suggests that we need to look, as you said, more closely at ways to improve our government's support of parents who face abductions and retentions. As you mentioned so eloquently in your opening statement, Mr. Chairman, Congress passed the Goldman Act to empower the State Department with tools or sanctions to discipline countries who enable abductions and retentions. I understand that you invited the State Department to participate with us today, and I must say that I'm very disappointed that we don't have any State Department officials here today to testify on how we can work together to strengthen our support for the brave parents like Mrs. Littleton. I follow the travels and the work of our Secretary of State, who clearly, obviously, gives that job absolute 100%. And I just can't tell you how I'm disappointed that none of the other 60,000 plus employees of the doggone department could not find time to show up today and participate in this important hearing that you've called. Very disappointed, and maybe I may bring that to the attention of the Secretary. These are doubtless difficult circumstances when a child abduction intersects with our foreign relations, but we must try to do better. And again, Chairman Smith, I want to thank you for holding this important hearing and allowing me to participate. I yield.
Thank you very much. I'd like to now introduce our three outstanding witnesses, noble parents who are fighting for their children, beginning with Jeffrey Morehouse, who is the Executive Director of Bring Abducted Children Home, or BAC Home, a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan. Bring Our Children Home strives to end Japan's human rights violation of denying children unfettered access to both parents and works to increase public awareness through community outreach on international parental child abduction. His son, Moki, remains kidnapped in Japan despite Mr. Morehouse's U.S. sole custodial order being recognized by the courts in Japan in both 2014 and 2017. He is also a founding partner in the Coalition to End International Parental Child Abduction and the G7 Kidnap to Japan Reunification Project. We'll then hear from Juan Garreco, who is the father of 2 boys, Mateo and Martin, who were updated to Ecuador, who were abducted to Ecuador in August of 2016. Mr. Garreco decided to start his own independent financial advisory practice in 2004, the year Mateo was born. His independent financial advisory practice allowed him to fulfill his commitment to spend more time with his children. Previously, he worked for a select number of investment banks in New York and Miami, and he is here today to make that appeal for his 2 children, and we're grateful he's here. Then we'll hear from Michelle Littleton, who is the mother of 3 children, Asila, Layla, and Yosef, who were abducted to Lebanon on January 4th of 2017. After her children's abduction, Ms. Littleton moved from California to Florida to be with her family. She was hired as an administrative assistant to the director to launch operations at Cape Canaveral Air Force Station as a contract hire for United Launch Alliance. Ms. Littleton is also selected as an ambassador to the United States Launch Alliance. Previous to her current position, she worked as a commercial real estate company, but put her real estate career on hold in order to pursue and try to bring back her children. Ms. Littleton awaits the day when she is reunited and has rooms furnished and decorated in her home on Merritt Island in Florida for the day when they come home. Mr. Morehouse, the floor is yours.
Thank you, Mr. Chairman, and to the committee for inviting me here today to share my expertise and my personal experience on the ongoing crisis and crime of international parental child abduction in Japan. Japan is internationally known as a black hole for child abduction. To date, as you mentioned, there have been more than 400 U.S. children kidnapped to Japan since 1994, and the government of Japan has not returned a single American child to an American parent. Over the years, many Japanese citizens and officials have shared with me that they are deeply ashamed of these abductions and need help from the U.S. and other countries to change it. They've asked for continued public foreign pressure as it gives them the support needed internally to uproot this cabal of resistance in Japan that continues to corrupt the family court system there. This is revealed in itself in what's called the continuity principle, or simply put, judges and attorneys representing abductions and abductors, and they manipulate the best interest of the child to rule that the child should remain alienated and ignore how they ended up with the abducting parent. When Japan acceded to the Hague Convention on the Civil Aspects of International Parental Child Abduction in April 1st, 2014, you, Mr. Chairman, you joined us as we met with the Japanese ambassador officials at the embassy to discuss their plans for implementation. And I remember walking out of that meeting, knowing that our worst fears had been realized. They had no real plan to uphold the spirit and the intent of the Hague Abduction Convention. It was all misdirection, all smoke and mirrors. What we foresaw then remains true today. Under Article 21, and I'm quoting here, it says, "The central authorities are bound to promote the peaceful enjoyment of access rights and the fulfillment of any conditions to which the exercise of those rights may be subject. The central authorities shall take steps to remove, as far as possible, all obstacles to exercise these rights." In the first known case to pursue Hague access rights in the Japanese courts, Canadian Henrik Teton requested interim access to his children and was ignored by the court. The judge refused to provide his name, therefore making accountability in these rulings impossible. No observers, no embassy officials were allowed to witness the court proceedings. 4.5 years later, 4.5 years ago, at the very moment Japan acceded to the Hague Abduction Convention, parents joined Bring Abducted Children Home to hand-deliver 30 Article 21 access applications. Hague was supposed to be an efficient path to see our children again. We were told at that time we must give Japan time. We must wait and see. Well, we've waited and we've seen. Of those 30 cases, 3 parents reported receiving 1 Skype session with their children, and 1 reported 3 sessions before the kidnapping parent cut them off entirely. None of these parents have received true unfettered access to their kidnapped children. When I personally filed for access under Article 21, my ex-wife responded by filing a new motion for custody in Japan, citing my Hague application and weaponizing it against me. I had to put my application on hold for 3 years. After winning my case in Japan in 2017 and attempting to restart efforts for access, she's been non-responsive. In consultation with the Japanese Central Authority, the Office of Children's Issues is again encouraging me to file an Article 21 motion in the Japanese courts. This is grossly flawed. As I'll state later in my testimony, Japan now admits that all power to comply with court rulings rests with the kidnapper. Japan's implementation of the Hague Abduction Convention is an abysmal failure. Hague return orders have failed to be enforced time and again, although it states under Article 7, and I'll quote again, "Central authorities shall cooperate with each other and promote cooperation amongst the competent authorities in the respective states to secure the prompt return of children. The prompt return of children. It doesn't state the optional return of children. Japan fails miserably here too. The enforcement of the return orders fails every time unless the kidnapping parent willingly complies. Now, in Japan, an enforcement involves an official going to the home and asking for the children to come out, while the kidnapping parent remains inside, prompting them to stay and holding all power over those children. For James Cook, as the chairman mentioned, he testified to the subcommittee in April. Japan's courts overturned the return order because Mr. Cook had moved into an apartment and had to share a bedroom with his sibling after the enormous legal bills incurred from years in fighting in the Japanese courts. He took his case all the way to the Supreme Court of Japan, and the Hague Convention failed again there. Laws and treaties are being ignored. Mr. Cook's children remain abducted with the kidnapping parent. This is just another example of Japan's continuity principle at work, and it crushes any hope of reuniting with our kidnapped children. According to my discussion with the State Department, Mr. Cook's case would now be classified as a judicial resolution under their interpretation of the Goldman Act. In other words, Japan gets rewarded for finding a way to avoid returning children that are kidnapped from the United States. It's another example of Japan's systemic failure to return kidnapped children. It involves two Japanese parents that were living in the United States. I point this out because it's the second time that a case involving two Japanese parents received extrajudicial effort that I have not yet seen in cases involving a non-Japanese parent. Like in the Oregon case that ended in 2016, the enforcement of the Hague return order failed. In this new instance, a Japanese form of habeas corpus petition was filed in the Nagoya High Court, but it was not awarded. So the father appealed to the Supreme Court in Japan, which issued a ruling in March 2018, and they wrote 4 significant points in that. The child was found to be unduly controlled and influenced by the mother. The second point, therefore, the child's statement was not considered to be objective. The Supreme Court in Japan determined that the retention of the child was clearly illegal. And then the Japan Supreme Court remanded the case back to the Nagoya High Court, the lower court. In effect, the Supreme Court issued an opinion, but they didn't issue a return based on habeas corpus, which evolved out of this failed Hague process. Now, in July 2018, the Nagoya High Court issued a new ruling in the case. This time, the child was ordered returned, but the mother and the child immediately fled the court. It can be assumed that the government of Japan, the courts, her attorneys, and the police know exactly where the mother and the child are. But the enforcement of the return order remains to be executed. In 2014, the Goldman Act was signed into law in part to create accountability for countries like Japan that fail to return our kidnapped American children. Multiple tools were provided: a démarche, an official public statement, public condemnation, denial or cancellation of official meetings or state visits, the withdrawal, limitation, or suspension of U.S. assistance, and a formal request to extradite the kidnapping parent. To date, only démarches have been issued. All other tools have been ignored. While we still don't have a single case of the government of Japan returning an American child to an American parent. In April, the Senate Judiciary Committee took this topic up at a hearing. Senator Booker asked, and I'll quote, "Are we using the tools in the Goldman Act beyond démarches?" Assistant Secretary Carl Risch of Consular Affairs responded, quote, "Not to my knowledge." Chairman Grassley inquired, how many demarches have been issued since the passage of the Goldman Act? Mr. Risch, there have been many, but we feel that type of diplomatic engagement is the key to success in these cases. Senator Blumenthal probed, have you used any other tools? Mr. Risch concedes they have not. In response to the committee's follow-up questions for the record, Assistant Secretary Risch responded that from 2008 to 2015, 9,127 children were kidnapped, and only 3,992 were returned. There was no substantial change in the percentage in those 8 years. Some years it went up a few points, some years it went down. If returning kidnapped children home to the United States is the key measure of success, and it is, that would point to a failure in strategy, not success. This subcommittee in April also held a hearing that examined the lack of use in the tools, and at the hearing, Chairman Smith, you noted that since 2014, we've seen a decrease in the number of new abductions, but not an increase in the percentage of returns. And you noted that in your opening statement as well. Special Advisor for Children's Issues, Suzanne Lawrence, testified, and I'll quote from her, we do consider all the tools we have at our disposal, and we do that with our interagency partners and try to use the best tool at the best moment on a case-by-case basis. We consider them when we think they will be effective. Congresswoman Jayapal followed up, what would move the threshold in order to use those tools? What can we tell our families about what we're going to do differently than we've been doing now? Ms. Lawrence replied, I don't have a specific answer for you on what the threshold is. Congressman Harris commented, is it going to take literally an act of Congress and an appropriations bill to get you ramped up through the escalating sanctions that can occur in some of these countries that the State Department has been unwilling to pursue? And Chairman Smith, you hit it right on the mark. Sanctions work. If Japan doesn't get it through your persuasion, and I thank you for trying so hard, it's time to lower the boom. And the State Department's response to those hearings was to ignore Congress's call to use the tools. A comprehensive review of all 4 actions reports from 2015 to 2018 shows a very bleak pattern. Many of these countries cited are repeat offenders, yet no other tools other than a démarche was utilized. Japan had 3 démarches in 2017 alone. In fact, other tools were only mentioned 1 time. In the 2018 actions report, the department, they claimed, the department wrote, the department is considering the use of further tools under the Act if Japan continues its pattern of noncompliance in failing to promptly enforce convention court orders. In an open session of the Diet in Japan in early 2017, the Japanese foreign minister at the time, Fumio Kishida, declared, there's not a single example of sanctions under the Goldman Act. He called them out. He called the State Department's bluff. Through multiple hearings in the House and the Senate, the State Department has rejected your calls, Congress's calls, to use the tools. Clearly, démarches, raising IPCA cases with foreign government officials, and empty threats are not bringing children home. And what are these démarches? What's in them? Does anyone really know? I'm still waiting for a response to a FOIA request that our organization submitted in February. What is it going to take beyond démarches? When are the interests of American children that have been kidnapped going to be put first? And when will decisive efforts be made to bring abducted children home? Based on multiple discussions with state, it's clear that Japan anticipated being cited in 2018. It started at least 6 months in advance. There was a démarche in November of 2017 and December. Japan knew what was coming, and they were preparing to spin their way out of it. On May 15th, 2018, as Japan was about to be cited for international parental child abduction by the United States, they held a public seminar at the House of Culture in Japan in Paris, co-organized by the Ministry of Foreign Affairs of Japan and the Japan Bar Association, Federation of Bar Associations. An audio recording of this event from inside, we hear participants being educated about the Hague Abduction Convention. They are taught how to prevent having their children returned to France, should they be taken, without consent to live in Japan. More simply put, the organizers lay out how to abduct to Japan and get away with it. By creating a seminar that advised potential abductors how to circumvent a Hague return order, the government of Japan has exhibited a shocking and blatant disregard for this international agreement. When they were exposed and confronted by French Senator Richard Young, Japan's Ministry of Foreign Affairs tried to deflect it as a rogue act by a presenter they invited. Now, if that were true, somebody from the Japanese government staff would have immediately interrupted at the seminar and disavowed their government of this. They would have denounced it right then and there. They didn't do that because it wasn't a rogue act. It was intentional. The government of Japan is a shameless co-conspirator. I'll note that seminars continue to be held, and there's little reason to believe that the content has changed. There was one scheduled in London, and I believe there was another one scheduled in New York. In June of this year, just after Japan was cited by the United States, their press reported potential draft legislation to purportedly address the child abduction issue. This was an attempt to change the narrative. It noted that there's nothing under Japan's legal system to deal with parents who refuse to hand over their children in defiance of a court order. The proposal on an interim report considered fining parents to encourage them to voluntarily comply. Now, fines and voluntary compliance already exist, and they haven't solved the problem. Fines can be levied, they can be imposed, but they have to be collected and substantial enough to bend a kidnapper's will of defiance. That's a very narrow and unique set of circumstances. It's not a judicial or legislative reform. As this potential draft limped along, in September, it was reported in the press, the rules now call for giving more power to enforcement officers and allowing handovers to take place in the presence of parents with custodial rights. On condition sufficient consideration is paid to the sentiment of the children. We've got to unpack this a little bit. It sounds good, but there are two immediate problems with it. First, a Hague case has to do with habitual residence, not custodial rights of the child. There could be a parent seeking a return order that might not have sole custody or the recognition of being the custodial parent in Japan or under Japanese law. It's habitual residence that we're dealing with. Second, what is it that they mean by sufficient consideration paid to the sentiment of the children? It's another loophole. What is the sentiment of a child going to be after they've been alienated for months or years? They're going to be filled with confusion, fear, anger, anxiety, all directed at the parent who's here to take them home. Is this, quote, sufficient consideration going to dictate enforcement is still abandoned because the child appears more accustomed to living a life under duress? These are subversive efforts to give the false impression of progress in Japan. It's more smoke and mirrors. Though the State Department has put great hope in Japan's potential legislation, a recent discussion I've had with them reveals that they were working on a draft from the summer, not the current legislation. The current potential legislation. It's not even a bill yet. The current version, according to our partners, have gutted the bill and would be completely ineffective if it's ever passed in a year or years down the road. So don't be misled by reports in the Japanese press and from State Department meetings with the government of Japan of sweeping legislative changes to improve our kidnapping crisis. Japan should not be rewarded with more time to fix problems that were exposed years ago. Let the kudos come after our kidnapped children are returned. In May, my colleague and I met with Japanese embassy officials to try and better understand, is there any genuine path for Japan to reunite parents with kidnapped children? The head of Chancery, which I think is essentially their number 2 person there, Mr. Takuya Sasayama, was shockingly candid to us. He said, your access depends on the mother and the child's wishes. In November, the State Department met with officials in Japan at the Japanese Central Authority to again raise cases of American children kidnapped to Japan and the lack of progress and failures in enforcement of judicial rulings. 2 weeks ago, I received a comprehensive readout from the Office of Children's Issues on this, and there were 3 points I want to share with you. Japan acknowledged that 1, if the parent refuses, there are no repercussions for ignoring an application for access, a return order, or a court order. 2, enforcing a court order depends on the voluntary cooperation of the kidnapping parent. And 3, the kidnapping parent knows this, and they hold all the power. Is this Japan's new tactic? Admit the problem and blame the kidnapper? We need real solutions to the numerous clear-cut cases, such as Naval Captain Paul Toland and Paul Wong. Though they're both the only living parent, the grandparents in Japan are holding their daughters from them. There are cases like Randy Collins, whose ex-wife was ordered to surrender the child's passport to the court, and instead she kidnapped him. Douglas Berg's children were kidnapped from their habitual and legal residence in the United States in 2009, violating his parental rights to access. Marine Corps Sergeant Michael Elias' 2 children were kidnapped to Japan after a U.S. court ordered no travel for those children. The list goes far on and on. It's far too long. All children and families crushed by the government of Japan's unwillingness to uphold its moral, ethical, and treaty obligations. There are thousands of cases within Japan that must be remembered too in this process. In my own case, I was granted sole custody of my son in the state of Washington in May 2007. 3 years later, on June 20th, 2010, I dropped my son, Mochi Atomu Imoto Morehouse, off to begin a week-long visit with his mother. He was 6.5 years old at the time. This is where my nightmare began. 6 days later, I received a phone call that no parent ever wants to receive. It was the police. My son, my ex-wife, had been reported missing. I knew immediately what had happened. She had succeeded in what she'd been planning all along. She had kidnapped our son to Japan. At this moment, my life had been shattered. I did everything I could to prevent this. There were passport and travel restraints in place. I had a court order that barred her from leaving the state of Washington with him. The Seattle consulate of Japan had denied her passport request when she went there, and she simply went to the passport office at the Portland consulate of Japan, which issued her one, in violation of the Ministry of Foreign Affairs' own policy. Over the years, some people have said to me things like, "At least you know he's safe with his mother." He might be somewhere in Japan, but he's not safe. He's at risk. He's been willingly and intentionally kidnapped to a foreign land with the intent of alienating him from me and everyone he knows. Imagine being a small child and your mother steals you away to a foreign country and tells you your father doesn't want you anymore or he's dead. Your whole life is now built on a foundation of lies. This is not what a healthy, nurturing parent does. It's child abuse. In 2014, and again in 2017, I won another landmark ruling in Japan. The court declared my U.S. sole custody order has legal effect. My ex-wife has no legal custody rights in Japan. None. They also cited her admission of illegal acts of passport fraud and forgery. There was no intent to offer justice, though. It was simply the continuity principle at work again. Doesn't matter how a child ends up with an abductor. Japan will not uphold laws and treaties to return children to their rightful home. In the end, the court refused to even reunite Mochi and me. I don't even know where he's being held. Our kidnapped children's true voices have been silenced. They need to be heard. In the beginning of my most recent legal battle in Japan, my son, 13 at the time, was asked by his attorney, "Do you ever think of your father?" And he replied, "Sometimes I dream of him at night," as he cried, telling that lawyer, "The last time I spoke to my son, the last time I saw him, was on Father's Day of 2010. I love you, Mochi, wherever you are. On behalf of the 66 children listed on the Back Home website, and those who have all been rendered voiceless by their abductors, for my fellow parents of internationally kidnapped children here today and watching all over the world who feel marginalized by the lack of active, engaged, transparent assistance in recovering our loved ones, I implore Congress to take strong, unified action toward Japan for its ongoing refusal to return our kidnapped children. For the past 2 years, Prime Minister Abe has spread it all over the press how President Trump and the U.S. are going to help Japan resolve the 1977 to 1983 kidnappings of 17 of their citizens kidnapped in North Korea. I feel for those parents. I understand their pain. It's our pain. And the U.S. should help. It's the right thing to do. President Trump ran on putting America first. Well, putting America first means putting America's kidnapped children first and bringing them home. Prime Minister Abe, what about returning the 400-plus American kids kidnapped to Japan since 1994? What about returning Mochi? The government of Japan throwing their arms up in the air and saying, it's up to the kidnapper. It's not acceptable. The government of Japan is complicit here. Last week, Secretary Pompeo said to the German Marshall Fund in Brussels When treaties are broken, violators must be confronted, and the treaties must be fixed or discarded. Words should mean something. How will Japan be confronted? In September, the President addressed the United Nations and declared, quote, "We're standing up for America and the American people." Who's standing up for America's kidnapped children? Words must be backed up with actions so that Japan will recognize that enough is enough. And the United States will not tolerate the ongoing kidnapping and retention of our citizen children. In Vice President Pence's press statement from his November trip to Japan, he stated to the Prime Minister that President Trump has made a commitment to, quote, "speed up the sale of defense technology to Japan." And we're keeping that promise. Before the end of the year, we will deliver 10 F-35s to Japan and 6 more in 2019. I urge Congress to take immediate action while the opportunity exists and block the sale of defense technology to Japan until our kidnapped children are returned to us. They've broken their treaty obligations. It's necessary to stand up for the American people here. Create the sanction, please. Stop the delivery of the F-35s. Tell the Prime Minister it is not acceptable to continue to hold my son Mochi, Atomu, Imoto, Morehouse, or any of the 400+ American children kidnapped and retained in Japan.
Mr. Morehouse, thank you very much for that very persuasive testimony on behalf of your son, as well as all the other left-behind parents who are being, I believe, cruelly mistreated by the government of Japan. Thank you so much. We'll now hear from Mr. Gareko.
Thank you, Mr. Chairman. Chairman Smith, members of Congress attending this hearing today, on behalf of my 2 children, Mateo and Martin, I would like to thank you for giving me the opportunity to speak here at the United States Congress about international parental abduction and the Goldman Act to return abducted American children. It has been well documented that international parental abduction, in most cases, is not an act of love, but rather an extreme form of child abuse. Children who are victims of parental abduction usually have already gone through the pain of their parents' separation or relationship breakdown. Due to the unilateral decision of one of their parents, these children then face the trauma of suddenly losing contact with their mom or dad, the left-behind parent. Sadly, this is precisely the case of my 2 boys, Mateo and Martin, who have been deprived of any contact whatsoever with their dad for over 2 years now. The effect of international parental abduction on children can be catastrophic. An essay published by the American Bar Association reports that, I quote, "Children that are abducted for over 6 months display severe psychological trauma and severe social disorders that will likely not be resolved as long as the child stays with his or her abductor. Although reintegration with family after many years can be difficult for the child, this is often the only chance the child will have to overcome the issues caused by the abduction. Most children are found to improve with the stability of being home with a searching parent and attending therapy." The essay goes on and says, "Children of long-term abductions report a feeling of resentment toward both parents. The abducting parent for stealing them, and the left-behind parent for not rescuing them sooner. And the longer a child is on the run, the more emotional damage is done. Abducted children have a high rate of seeking out their left-behind parent as teenagers and adults, always seeking reunification even after many years apart. This suggests that returning a child to a left-behind parent, even after many years, is often what is best for the child, and is what the child desires, end quote. Shortly after my children's abduction in August 2016, I found much needed encouragement and hope from a press release dated November 18, 2015, from former Secretary of State John Kerry. And I'm going to highlight 3 paragraphs of that statement. 1, according to the press release, one of the Department of State's highest priorities is the welfare of children involved in international parental child abduction cases. And one of our most effective tools for resolving these cases is the Hague Abduction Convention. 2, in 2014, Congress passed the Sean and David Goldman International Child Abduction Prevention and Return Act, which gives the Department of State additional tools to advocate for the return of the abducted children. And 3, there can be no safe haven for abductors. There can be no safe haven for abductors. So I'm going to focus my testimony on those 3 topics. After fighting for over 2 years to secure the return of my children from Ecuador, I have found the following conclusions. 1, the Hague Convention has not been an effective tool in bringing back my children from Ecuador. 2, the State Department has not enforced the tools provided by the Goldman Act. And 3, the abductor seems to have been successful in finding a safe haven in Ecuador, a Hague partner country that has been listed as non-compliant by the State Department for several consecutive years. Let me talk about the Hague Convention. In principle, the legal remedy available through the Hague Convention of seeking to have the abducted children returned to their habitual place of residence aims to achieve a fair process. However, in non-compliant countries, reality is rather different. As soon as the taking parent abducted my children to Ecuador, she filed lawsuits for divorce, parental rights, and child support, 3 different lawsuits. Classic case of forum shopping. Henceforth, she has retained 13 attorneys from 9 different law firms in Ecuador in 2 years. 13 attorneys from 9 different law firms in Ecuador, none in the US. When we served her for divorce proceedings in the US, she did not even bother to retain an attorney from the United States. She did not appear in court, and the court gave me full custody and parental rights of my children. But she continued on with the cases in Ecuador. The 13 Ecuadorian attorneys were not retained randomly. They are rather widely known for their political connections in Ecuador and questionable unethical illegal practices. In fact, the very first attorney, Mónica Arellano, chosen by the abductor in Ecuador, is the wife of the person who was acting at the time as the Minister of the Interior, the head of police. My attorneys warned me in Ecuador, don't come to Ecuador. The wife of the Minister of the Interior has the police at her disposal. Don't even bother coming to Ecuador. Subsequently, the taking mother retained the services of 2 attorneys, Maria Belén Pasquel and Maria Gracia Pazmiño, who are known to be close friends with the person acting then as president of the Judicial Council of Ecuador, Gustavo Jalca, who was recently ousted in Ecuador due to corruption. More recently, the taking parent retained the services of another attorney, Antonio Acosta, who has the reputation in Ecuador for allegedly engaging in bribing. It is worth emphasizing that we have documented a fairly large number of irregularities since day 1 in Ecuador. Let me share some of those irregularities with you as they pertain to the Hague Convention in Ecuador. The lower court hearing in April 2018, the judge, Marianela Maldonado, did not allow testimony from U.S. independent professionals that were going to testify via video conference. She just didn't allow them to testify. These professionals included family therapists and the guardian ad litem from Miami, who were appointed by a Florida judge. And they had first-hand knowledge of our family dynamics as they personally treated both parents and children for nearly 3 years. The lower court judge did not allow the U.S. custody evaluator, who traveled personally to attend this hearing in Ecuador. According to the U.S. custody evaluator, who had previously testified in other Hague proceedings in different countries, he found an extremely hostile environment in the Ecuadorian court. Most notably, the custody evaluator claimed, 1, that the judge demonstrated to be utterly biased, 2, that his passport was confiscated by the court until late in the afternoon, long after his testimony had concluded, and 3, that he was threatened with prison in Ecuador for perjury. He thought he was not coming back to the US. The lower court judge did not recuse herself from hearing this case, despite the fact that she maintains an intimate friendship with opposing counsel. Oddly enough, the judge and the abductors' attorneys were displaying public messages on Facebook of their mutual admiration and love precisely at the time when we were waiting to hear the hearing date for the Hague case. The lower court judge had a short private meeting with my boys before the Hague hearing. Based on that meeting, she denied the restitution of my children because she says that was the desire of my boys. In July 2018, the Court of Appeals, consisting of 3 judges, did not allow an officer from the US Embassy in Ecuador to attend the hearing. We don't know why. An officer from Ecuador's Central Authority was allowed to attend the lower court hearing. The panel of judges also met privately with my children, but this time it was with the presence of an independent child psychologist. After the hearing, the panel of judges announced that a final ruling would be issued in writing in the following days. However, they did announce that their decision to order protective measures in favor of my children in the form of therapies, which were necessary to reestablish the bond between the children with their father in view of the mother's strong opposition. The panel of judges several days later issued the ruling in writing, with protective measures included, denying restitution of my children because they considered that my children were well settled in Ecuador. So notwithstanding having dismissed the reason that the lower court judge had used to deny the restitution, the Court of Appeals proceeded to deny the restitution of my children based on the well-settled exception. It is abundantly clear that this ruling was made in violation of Ecuador's Constitutional Court and the Hague Convention. In 2017, Ecuador's Constitutional Court ruled that the one-year clock of the so-called well-settled exception stops when a petition is received by the Ecuadorian Central Authority. Interestingly enough, the lower court judge did mention in her ruling that our petition had been filed within 1 year of the abduction. However, this material fact was notoriously missing from the Court of Appeals ruling. As we speak, my attorney in Ecuador is filing today an appeal with the Constitutional Court in Ecuador. With respect to the Goldman Act, in April of 2018, when the State Department published its latest Goldman annual report, Ecuador was listed yet again as a country that demonstrated a pattern of non-compliance. Subsequently, in July 2018, the State Department published its report on the specific actions taken against countries determined to have been engaged in a pattern of non-compliance in their 2018 annual report on international child abduction. The following is the actual transcript of the full report of actions taken by the State Department with respect to Ecuador. It consists of 3 paragraphs. 1, the department has reinforced efforts urging Ecuador to improve its convention implementation. In January 2018, the U.S. Central Authority increased the frequency of digital video conferences with the Ecuadorian Central Authority, Ecuadorian law enforcement officials, and the Public Defender's Office to monthly meetings. 2, the department also plans to invite Ecuadorian officials to participate in a new international visitor leadership program scheduled for summer 2018. The International Visitor Leadership Program will specifically address the judicial components of processing and resolving convention abduction cases. And finally, the 3rd paragraph of this reaction report says, in June 2018, U.S. Embassy Quito delivered a démarche to the Ecuadorian Ministry of Foreign Relations, giving official notice that the department cited Ecuador for demonstrating a pattern of non-compliance, period. That's it. Those are all the actions taken with respect to Ecuador. And with all due respect, these actions, from the point of view of a left-behind parent, do not seem that impressive. Despite the fact that the Goldman Act provides powerful tools to the Department of State, it is evident that these tools are not being used. The State Department's actions report contains no sanctions whatsoever against Ecuador. In its action report, the State Department states that diplomatic engagement remains our most effective tool with all countries to assist in resolving international parental child abduction cases, end quote. I have no doubt, as a left-behind parent, that intentions are good and that the desire is there, but enforcement is clearly lacking. Soft diplomacy alone is not getting the job done. Finally, with respect to actions that might be helpful in resolving the long-standing abduction of my children in Ecuador, I would like to say the following. Critics of the Hague Convention are of the opinion that the United States government is powerless in its attempts to coerce foreign countries to obey or comply with the Hague Convention. To maximize impact and bring back American children abducted abroad, I personally believe that the US government should start announcing and implementing sanctions at the macro and micro level. This will send an unequivocal message to the world and the United States that the United States of America means business when it comes to bringing back its abducted children. So specifically, the executive branch should consider taking the view that American children are being illegally retained in foreign countries as a result of an act of kidnapping. With the implementation of economic sanctions, non-compliant countries will soon start complying with the Hague Convention, and American children will finally be rescued and protected from the harmful effects of international parental abduction. Economic sanctions can have a huge impact almost overnight. The United States is Ecuador's principal trading partner. Conversely, Ecuador is the 42nd largest trading partner of the US. Currently, Ecuador benefits from tariff-free entry into the United States for many of its products under the Generalized System of Preference, GSP. In Ecuador, the annual renewal of the GSP with the US is celebrated as a major victory. Under current President of Ecuador, Moreno, Ecuador is now expressing interest not only in negotiating a new bilateral investment treaty with the US, but also is exploring a commercial trade agreement between both countries. It is worth mentioning that Ecuador is currently facing a fiscal deficit that is unsustainable, and the country lacks any significant monetary policy maneuvering because its official currency is the US dollar. From an economic point of view, the country that seems powerless is Ecuador. If the US were to announce imminent economic sanctions against Ecuador, the days of non-compliance with the Hague Treaty would be over. 2, the Department of Justice should consider taking swift and immediate action against abductors and accomplices. Back in 2016, when my children were kidnapped by their mother, I went personally to the FBI Miami field office, as I had read that the FBI had jurisdiction under the International Parental Kidnapping Act. A special agent, FBI agent, told me on that occasion that the protocol is for the FBI not to get involved until the Hague proceedings in the foreign country were finalized. More recently, another FBI agent, special agent from Miami, emphatically told me, Juan, I'm telling you right now, the taking mother won't be indicted unless you win the Hague case in Ecuador. So the FBI is not going to take any action unless I win the Hague case in Ecuador. To my surprise, the FBI agent also told me that the defenses under International Parental Kidnapping Act and the Hague Convention were the same. My understanding, however, is that International Parental Kidnapping Act has 3 defenses, none of which is the well-settled exception. I would hope that the US law enforcement considers international parental kidnapping as a violent crime against innocent children and that the FBI becomes immediately involved without having to wait for Hague cases to be resolved overseas. Parental abductors usually count with a support network of family and friends who aid in the kidnapping and or its continuation. These individuals should be investigated and eventually be prosecuted if found liable for aiding and abetting. These accomplices, whether they are family, friends, or even family attorneys, should be criminally charged with kidnapping and conspiracy to kidnap. Prosecuting these individuals makes sense not only because they will be held accountable for their crime, but also because law enforcement may obtain valuable testimony against the abductor and or other accomplices. More importantly, Taking action against accomplices could, in some cases, persuade the abductor to voluntarily return children retained abroad. And number 3, the Department of State should consider implementing immigration sanctions against accomplices, irrespective of whether the abducted children were taken to a Hague partner country or a non-Hague partner country. The State Department can build a database with the names of all the individuals involved in the illegal retention of American children overseas, including family, friends, attorneys, judges. Under this scenario, not only the abductor and his or her accomplices, but also corrupt attorneys and judges could be properly interviewed when they visit an American consulate next time for their visa renewal. The problem in Ecuador is that corruption is endemic, especially in the judicial system. And this problem does not seem to be addressed by the State Department's action report on parental abduction. In Ecuador, judges are known for accepting bribes from unscrupulous attorneys and their clients. At the moment, there is no constitutional court in Ecuador because all of its judges, the 9 judges, were recently ousted due to corruption. Furthermore, a national court judge who was part of the panel of judges that heard my Hague case, is currently being investigated in Ecuador after a journalist published a report that her daughter has paid $1,000 in income taxes, $1,000 income taxes in the past 10 years. Not $1,000 every year, but in the whole 10-year period, $1,000 in income taxes, despite having inflows of several $1 million in her bank account. The possibility of denying US visas to these individuals can become an extremely powerful tool on preventing and resolving international parental abduction. While legislation may be needed, please, Mr. Chairman and members of Congress, consider implementing immigration sanctions as soon as possible against abductors and their accomplices, irrespective of the country of destination where the abductor has taken our children. I would like to finish my testimony by emphasizing that every day counts. Every single day counts. Time does not erase our memories or heal our pain. Time triggers an awful lot of daily reminders. Time is of the essence, and now is the time to bring our children home. The childhood of our children is in your hands. The fate of our children is in your hands. My special thanks to Michael for his extraordinary work at the Office of Children's Issues, and to Allison for her unconditional support throughout this difficult journey. And last but not least, I would like to send a brief message to my children. I love you guys. I'm here for you always. Thank you.
Thank you, Mr. Garreco, for that very powerful testimony. And your recommendations for additional actions, I think they were very well founded. Ms. Littleton, I yield such time as you may consume.
Chairman Chris Smith, Congressman Bill Posey, and distinguished members of the committee, thank you for holding this important and urgent hearing on international child abduction. My name is Michelle Littleton, and my 3 beautiful children, Asila, Layla, and Yusuf, were kidnapped from their hometown of Mission Viejo, California, by their father, Mazen Fauzi Matar, on January the 4th, 2017. It was the middle of the school year on what was supposed to be a 10-day vacation over Christmas break. While most children were returning to school, my children were boarding a plane and being kidnapped to war-torn Lebanon, where dozens of other American children had already been abducted to and never returned. For 1 year prior to the abduction, my family fought to prevent this nightmare from happening by pleading with Judge James Waltz of Orange County to prevent the trip. Eventually, Judge Waltz felt I was just being difficult and took my custody away so my ex could obtain passports without my consent. After he obtained the passports, I had to agree to the trip to have partial custody back. Judge Waltz should have listened to my desperate warnings. By not researching the Lebanese history of non-returns, he failed to protect the very United States citizens he serves. All judges should have awareness of IPCA and strongly consider the risks involved when approving international vacations, especially when one parent is communicating fears of abduction and the data is available to show that return from a particular country is extremely difficult or impossible. My worst fears for both of my daughter's safety and well-being became real when I requested the State Department perform a welfare and whereabouts visit. During the visit, the grandfather stated that my girls are almost of age to be married. They were 12 and 13 at the time. There have been times when the embassy could not visit the children, either because it was not safe for the staff to travel to Tripoli or because my ex-husband denied access. I have gone several months at a time without being able to contact my children. I cannot imagine the heartache my children must be feeling, especially my son Yusuf, who was only 5 years old when he was abducted and ripped out of my arms. With the help of my Lebanese lawyer, Mohammed Ayubi, I have been able to slowly but successfully navigate through the foreign and complex Lebanese court system. However, 2 years into my fight, and I am still up against my ex-husband's delay tactics from Lebanon enabling my husband's tricks. He has filed appeals to every victory I have won. I have even won full custody in Lebanon. The Lebanese civil and execution courts have ordered the children to be returned to me in the United States immediately. Not surprisingly, my ex filed an objection to the execution enforcement order based on what he calls no jurisdiction for the Lebanese authorities to enforce their own return order. It has been 3 weeks since he filed the objection to enforcement, and he may be able to run the clock for another 8 weeks or more with frivolous delay appeals. I am grateful that Lebanon has recognized the situation for what it is, a kidnapping, and issued orders for my children's return to their home here in the United States. But my ex, who is a U.S. citizen, is making a mockery of Lebanese courts, U.S. courts, and worst of all, putting at risk the lives of our children. This should not be tolerated by the government of Lebanon or the United States. I have not been able to see my children in 2 long years. I have asked if I could travel to see my children, but I'm told it's too dangerous. This is my painful reality and hell that I have been living for 2 years. I want my children home for the holiday more than anything in this world, and me and my children have the right to be together now, right here on American soil. It must end at once with my children at home with me. This could be a watershed moment for U.S.-Lebanon relations. Although the United States has had dozens of children abducted to Lebanon, I do not know of any cases before mine with a court order for return from a Lebanese court. In fact, there have not been any court order returns ever reported to the State Department. 0. With the current court orders in place in my case, Lebanon could for the first time return an abducted child to the United States. It would be a timely and welcome gesture of cooperation between Lebanon and the United States as we seek justice for children abducted, wrongfully retained in either country. It goes both ways. The State Department and law enforcement have been so helpful in my case, and I'm thankful that they have even more tools at their disposal in the Goldman Act if Lebanon fails to enforce the return orders they have issued. Almost $200 million and so much more is provided in aid to keep Lebanon safe and strong. So much is at stake. Isn't it time for Lebanon to enforce the return orders that they have already acknowledged to send my children home? I call on the State Department to use every tool at its disposal to bring these American citizen children home immediately. And I appeal to Lebanon to please, quickly, enforce the return orders Lebanon has justly upheld. Set the example so that any parent now considering the child abuse that is child abduction will know that Lebanon does not aid kidnappers. I have one message for my children. I love you, and I'm fighting for you, and I cannot wait for you to come home. Thank you.
Ms. Middleton, thank you so very much for that strong testimony, for the appeal to our government to use every power at its disposal, to every tool to bring these American children home immediately. I think that's part of the message that we are trying to send to the White House and to the Department of State, that you have tools in that toolbox that remain unused, and because of that, the people on the other side of this issue, and that is to say the kidnappers, are able to game the system in such a way that they stall, they play out by years, and at the end of the day, your children and the children of so many Americans never come home while they're children, maybe as adults, but certainly not as children. So I do have a few questions I'd like to ask. Both Jeffrey, you and Mr. Gareko mentioned that you won in court. No, you've mentioned you won in court, Ms. Littleton. You won custody. On the enforcement issue, that seems to be perhaps one of the biggest Achilles heels in all of this. When even David Goldman, on whose case I worked, he was in a situation where he would win cases, and then they would just appeal, and went on for years. And it gets to the point where you spend so much money and time and effort, they hope that you'll just pack your bags and go home, which you don't do, and so many others don't do. They double down and try even harder. But at the end of the day, you get things like the Article 13B exception to return, which was used in the Cook case, saying, as they did in Japan, that living in an apartment is a, quote, grave threat to the children's well-being, which is absolute nonsense. A lot of Americans live in apartments. There's nothing wrong with that. It is a great way of if you don't have enough money for a mortgage or you're more transient, of just that's where you decide to live. But in his case, he had to spend down so much to get to the point where the very home, his abode, was a simple apartment. And then that's used against him in court again. So, Jeffrey, you might want to speak to that issue, because I think that is utterly perverse, that a court or any judicial or governmental body would use that kind of logic. And on the enforcement issue, you know, you mentioned, Mr. Guerreco, about the intimidation factor in the courts. You talked about the special, how did you put it, just let me get it correct. The custody evaluator said that on the case of the doctor from Miami, that he was threatened with prison in Ecuador for perjury. You know, the threat, however strongly it is made, of possible prosecution can have a chilling effect on what happens after that, and that goes for judges as well. If they feel they may be subjected to that kind of abuse, they may rule the other way. So you might want to speak to that as well, because I think the idea of restitution is a very dangerous a tool in the hands of a kidnapper and an abductor. So, and then finally, and then I'll go to Mr. Posey, and I do have some additional questions, to speak to the issue of, if any of you can explain or give any insight as to why you think both the Obama administration and now the Trump administration have not used the tools that were given to them. When I authored the Goldman Act, we took many of the prescribed sanctions that were embedded in the International Religious Freedom Act as a very good template on what we can do on a human rights issue, and this human rights issue is used against Americans and American parents who are left behind. And it seemed to me that we had a well-founded group of sanctions, and DeMarche was to be the beginning, not the beginning, the middle, and the end, and the only thing that is employed. It was not meant to be, it was just meant to be the warning shot before all the other sanctions begin to kick in. So if you could speak to that, and then you've all, in your testimonies, made an appeal for that, but if you could also just, in a couple of sentences or two, if President Trump were sitting here, if Secretary Pompeo and others in the chain of command were sitting here, because they have to execute the laws, they have to implement the laws, we write them, but we do oversight as well, and that's what this is, to say, please, Mr. President, just implement the law. And as you said with the GSP, Mr. Guerreco, if GSP was put on the chopping block, the abductions would go away. They would stop this horrific game, this dangerous game, this ugly game of siding with abduction and with kidnappers. And then I'll go to you.
So in response to the question regarding how it works in the courts in Japan and the exceptions they're creating, it goes beyond just the Hague Abduction Convention and really falls all under the continuity principle, where they will not change current circumstances and really just ignore how the child ended up with the kidnapping parent. We saw this play out in Mr. Cook's case, where they engineered the end conclusion that they wanted to get to, which was to not return the children, by crafting a best interest of the child argument based on living in an apartment. And as you pointed out a moment ago, many Americans live in apartments. My son, when he was born, we lived in an apartment in New York. It's a very common part of American society. And I'll note, also in Japanese society. So it's really kind of a hollow argument that they made there. In my own case, as you may or may not recall, the last case took a year. We thought we had a real chance at proving that he had a great life available to him here in the United States at home. Went through all of the motions. I had to present to court investigators pictures of my house, my neighborhood, square footage, all of these great attributes of living in the Seattle area. And they just sat there and marveled at photographs of a very average American house, discussed that, asked me several questions with no real intent of doing any judicial investigative process. It was all pre-engineered, even to the point of the fact where they asked for us to present a reunification process for Mochi and me. And we drew it out in a very Japanese style. It was going to span about a year to reunite him, which truly is absurd under the circumstances, but I was willing to go to that extent. They never even looked at it seriously in their ruling. They simply ruled that the U.S. custody order that I've had since 2008 has legal effect in Japan, denied her all custody rights under Japanese law. So ergo, I am the sole custodial parent of our son, both in the U.S. and Japan, and they are unwilling to enforce that. And then simply on the unwillingness to reunite, I think that was based on, as I testified earlier, he expressed his true opinion months earlier to an attorney. They had many months to sanitize that response and provide an answer for what the court wanted to hear in order to justify not reuniting Mochi and me. Just another example of how the continuity principle works in Japan.
Mr. Chairman, with respect to the intimidation issue in the lower court in Ecuador, the U.S. custody evaluator, Dr. Miguel Firpi from Miami, is a very well-known professional that has over 20 to 30 years experience in hearings. And he's one of the few people actually in Miami who has gone to different countries to appear in hate cases. And he called me the following day and he said, Mr. Garaycoa, I cannot explain this to you, but I have never, ever experienced something like what happened or transpired yesterday in Quito. I'm glad to be back in Miami. At one moment, I thought I was not coming back. The opposing counsel threatened me with calling the district attorney's office that day, at that time in the afternoon in Ecuador. I was threatened that my passport would not be given back to me and that I would not go back to the US because you are committing perjury. He was not, and these two, the judge did not contain the opposing counsel. She kept quiet. So Dr. Firpi told me I could not give my testimony in a free manner. And to my surprise, the other professionals that were about to testify via video conference were not allowed to testify. And I'm sorry to tell you, but the judge was completely biased, and this is not looking good. The hearing that day did not finish, did not end, because there were other witnesses in Ecuador, but he told me by the day this hearing is over, chances are is that the judge is going to rule against you. And that's in fact what happened. Dr. Firpi told me just last week when I knew about this hearing in Congress, he told me that he would be willing, more than willing, to testify here at some point. And I think it would be interesting for you to hear from an independent professional how a foreign court works, and whether that court is being fair or unfair, and he's willing to come or to testify via video conference at any moment in time.
Thank you, Chairman. Thank you, Chairman. I think that in general, it's very easy to look at Lebanon and recognize that they are not compliant. So far, no children have ever been returned from Lebanon. I think we're moving forward into a better space and relationship with them. They're definitely putting the right foot forward. They're here today. But more has to be done. And the fact that there's never been a child returned from Lebanon is frightening as a mother who has daughters who could be married off. And we know that because the welfare and whereabouts visit that the embassy did prove that. So, I mean, are we going to send them another demarche when my daughter is married off?
Mr. Garrett?
Mr. Chairman, the only people more frustrated in this room than perhaps yourself and your staff than me are the ones at that table. And I want to concede that on the front end. Having said that, and I'm leaving this body in just a few short weeks, and there are a lot of reasons I'll be glad to be gone. And one of them is that we sit in this room oftentimes and identify real problems with real victims, many of whom are human beings, every one of whom has import in my worldview to include not only yourselves but your children. And we talk at these problems and we don't solve them. Now, I want to commend the chair of this subcommittee, Mr. Smith. Goldman has the teeth to make this happen. But there are 435 members, 441, concluding non-voting members in this chamber, and 100 across the hall. And there's one guy sitting in the White House. And everything in this world tragically becomes a carrot and a stick, and we have the stick to make the Japanese and everyone else play ball if we're willing to use it. What I've seen in so many areas, and I shall not digress, as it relates to U.S. policy with regard to anything from who we support in conflict zones abroad to whether or not we put a priority on the sanctity of your familial relationships with the people who you love in a way that we can't understand unless they're our own family members. We subrogate oftentimes that which is seemingly micro for the macro. My submission would be that if we do the small things right, the big things generally will tend to take care of themselves. But I hope that somebody in the executive branch is watching this because they can fix this right now, simply by suggesting that 12 F-35s might become 10 or what have you. These things aren't terribly important, tragically, to the people in the executive branch, whether in this country or abroad. If they were more important, I'll bet we'd see some movement. Having said all of that, again, this is not in any way to impugn the folks in this room. I think Mr. Smith has done all that can be done over a number of years, as have each of you. But these are things that we need to get on the radar of the people who can make the changes immediately. And again, I'm not trying to lecture you. You all know this. I can't begin to have empathy, praise God, for each one of you and your suffering. But it matters. It ought to matter. And if Congress were to decide that we were going to fix this, and we really leaned into it, it'd probably be fixed in a few years. We can fix this at Pennsylvania Avenue now. And so I hope someone's looking. I hope a phone call is made. Again, I understand that there are courts, et cetera, of basic jurisdiction in various places, but some of these cases that you're describing, cut and dried, right? Agreements on both sides of the water. So I wish that my words mattered. I hate mere words, but I commend you for what you're doing. To the extent that I'm able to help during my time here and after, I will. This is really, truly symptomatic of mistakes that we make, I think, in the foreign policy realm by virtue of prioritizing relations, say, with Japan over relations between a mother and child, father and child. And I, again, think that you can have good relations with our colleagues in the global community and prioritize those familial relations. And candidly, I don't think they're mutually exclusive. And secondarily, I think they might be even better if we showed that we actually adhere to the values that we say we do. Because that's where I think we fail in the grand scheme. People are looking to see what this country does, not what it says. And what we're saying is all the right stuff. What we're doing is not generating the results. So I thank you and yield back. And I genuinely and sincerely thank you for the privilege of having been able to work with you. And again, I wish condolences meant anything. It's tragic what you all are going through, and I hope that it sees a rapid end. But I fear that until we attitudinally shift how we do business internationally, that it'll continue. Thank you.
Thank you, Mr. Garrett, and thank you for your service on this subcommittee and your profound commitment to human rights. Mr. Posey.
Thank you again very much, Mr. Chairman. And again, be remiss if I didn't state how disappointed I am the State Department is not here and can't help answer or validate some questions that have arisen because of the testimony that we've heard here today. For example, the last time our staff and I met with Ms. Littleton, the Department of State was there, and we talked about a number of different approaches that they might try to execute to make these things happen a little bit more efficiently. They promised to update us, and they did, in fact, recontact us and tell us that the local law enforcement had gone to the children's school to execute an order, and they planned actually to take the kids into possession and return them to you. But can you just imagine on that particular day, the kidnapper didn't let the children go to school, and he refiled the appeal every other finding. So, you know, I think the pressure, the political pressure, definitely needs to be applied at a higher level. As is mentioned here, when we interface with the local authorities, there's obviously more than a little bit of corruption, and they're not on our side like so much of the international community. Do you know, each of you, if any criminal charges have been filed against a kidnapper?
Yes, I'm aware of criminal charges being filed.
Have they been filed? It's been 8 years.
Yes.
Have they been filed?
Yes.
Is your ex wanted by the FBI for interstate transportation of children illegally, or what's the charge?
It's under IPCA, the International Parental Kidnapping Crime Act, and passport fraud.
Okay. How severe is the penalty for that?
I'd have to look at the statute, but they are extraditable because it does meet the comity. It meets Japanese law under the interpretation of the Department of Justice.
Because that's pretty significant. I think that got left out of the testimonies here. Sir, in your case?
To my knowledge, in Ecuador, or people who have found a safe haven in Ecuador have not been criminally charged by the Department of Justice here in the U.S.
But where were your children kidnapped?
My children were kidnapped to Ecuador. They were taken from Miami to Ecuador by their mother. And I met with the FBI in Miami, and they told me they're not going to do anything unless I win the Hague case in Ecuador.
Okay, so you have to win a case against Ecuador, a foreign court, before, and I wonder why your FBI office is different from your FBI office.
If I could address that briefly, my colleagues and I have met in the past with the Office of the Attorney General at DOJ, not directly with the office, but underneath in the building. And we've cited the fact that there's been gross inconsistency in the FBI throughout the country with regard to responding to parents of kidnapping cases. I've seen instances, as he's described, as well as parents being turned away, claiming that the parent needed to file local charges first. Nowhere under the federal statute does it require any sort of prerequisite. So I do not know if it is a fundamental lack in training, policy, or just a desire to push parents away because in the end, these cases are hard to prosecute and they'd rather put resources elsewhere. But it is important to actually get this on the record and get it cited. And the last thing I'll just add in response to that is our coalition of organizations has asked for the past several years for DOJ to provide statistics on how many cases they have pursued and indicted under the International Parental Kidnapping Crime Act of 1993. To date, they have declined, stating that they do not collate those numbers and advised us to reach out to each district office throughout the country. Frankly, I think that's kind of a nonsense response, but that's what they tell us.
Thank you. I'm not a lawyer, but I think your court proceedings make it very clear that the children have basically been kidnapped out of Miami, and I'm shocked that you couldn't get any charges filed, and he could. Ms. Littleton, how about you?
There's a federal warrant from the FBI for international parental childhood abduction. There is a warrant.
There is a warrant. Okay, so 2 out of 3. But
if I could just add to that, in my experience in knowing hundreds of cases, we are the outliers that actually have received response and indictments by the Department of Justice. It's highly unusual.
Okay, thank you. And again, you wonder what the parents are telling their home countries too. You know, that are obviously taking the kids, the kidnapper's side, and it would be like if you went over there and kidnapped your kids back and brought them over here, they would be filing motions saying that you molested the children and all kinds of terrible things and why we should send them back to the country with them. I mean, so, you know, it's not clear cut probably to the other side of the authorities either. They don't hear your side. They're obviously just getting the other side. Do we know if there are children in the United States who have been abducted in other countries by Americans and are held here, and the people from the other countries are trying to do just the opposite? Are we aware of that?
Yes, there are cases where children have been kidnapped from foreign countries to the United States.
How many?
I don't have exact figures on that. I do know the Department of State publishes those numbers, or did in the past on their website prior to the Goldman Act, and they would list year by year the number of incoming cases, as they call it.
Okay. Do you know how the status works on any of those? Do we respect the foreign court's jurisdiction?
My understanding from meetings with the Department of State on that topic are that's handled by the courts that adjudicate it, and the general answer could be yes, but I think as you pointed out, they get into the details and the he said, she said component. So one could make an argument that we may not be perfect on this as well. However, I do think our American rule of law does apply, and hearsay is probably not allowed in those jurisdictions the way it is in Japan, and I presume in Lebanon and Ecuador and many other countries that stack the deck against American citizens when our children are kidnapped abroad.
Yeah, you'd think there should be maybe an international court, but then you see what happens at the UN, same thing. You know, it's all against us. Just out of curiosity, is Judge Wald still on the bench?
Yes, he is.
You would not have had a problem were it not for his poor judgment, if I understand your testimony correctly.
That is correct.
Is he aware of what this turned into?
He's fully aware, and he actually finished doing the final court orders, the final return orders that we submitted to the Lebanese civil court that Lebanon has acknowledged. So he has tried to make it right or rectify it, but I've been left to the fate of my lawyer in Lebanon using the court documents that Judge Waltz is now sending, so to have my children returned.
And he seems like your attorney there. I was on the phone with you one time when you did a conference call, and he seems pretty confident and seems confident and competent. And I guess he did get everybody to the point they wanted to go until the local police muffed the execution of the order for whatever reason or however reason. The kidnapper knew about it, and you know that's kind of sad. Mr. Chairman, I think it's really clear that we need to get some level of the State Department involved, at maybe a higher level, that would actually want to show up at a hearing and see what was said and be up to date on this stuff. And I think to the point of the witness today, clearly the local level of governments are not going to be responsive. I don't think we're going to expect to see any change of behavior on their part unless we get higher level interaction on our part. And they've all mentioned the possibility of sanctions being the key. And I mean, this is not on the radar screen of most Americans, but if you know about one of these cases and you know about the injustice of one of these cases and you think about the children of these cases, it should shoot far up the interest screen of any agency, particularly our Department of State. But you know, I don't have an answer right now except some of the things that I've expressed that we should pursue further with our Department of State. But I just want to thank you for your interest in this, as you have so many other humanitarian issues and stood on so much principle for the betterment of mankind. I'm deeply grateful to you, sir.
Mr. Posey, thank you very much, and thank you for being such a great advocate for Ms. Littleton. I think that shows a clear concern for, as she put it, the hell that she is living, having 2 years now, having her children abducted. You did mention in your testimony, as we've seen so many times all over the world, you've won case after case. You have full custody, and yet there's always the frivolous appeal that follows by your ex. And my appeal from this chair now to Lebanon, as you pointed out here, with the current court orders in place, in my case, Lebanon could, for the first time, return an abducted child to the United States. It would be a timely and welcome gesture of cooperation between Lebanon and the United States as we seek justice for children abducted or wrongfully retained in either country. I mean, that is a level-headed appeal to a country with whom we have strong relations and friendship, notwithstanding some other issues that complicate it at times. But this seems to be, on a purely humanitarian basis, something they could do tomorrow, enforce the orders. And I hope that they will take that from you being here today. And I would point out, and I'm grateful, there have been many members of the press here today. C-SPAN has also covered this, and we're deeply grateful for that, because that allows the American people to hear you and to hear what American parents are suffering because of parental-child abduction. And Mr. Posey, as you pointed out, we have had the State Department here before. We've had high-level individuals. For the record, when I introduced this, it took 5 years to get passed. The Obama administration was opposed to it when Hillary Clinton was the Secretary of State. John Kerry got that position changed within state, and I'm grateful to him for that, and because we would pass it in the House and would languish and die in the Senate, and it took 5 years to get the Goldman Act enacted into law. But a law is only good as its enforcement, and certainly the prevention part of it is doing better and doing well, not as good as we'd like it to be. But the second part, the returns of children, has been a failure. And it's only a failure due to lack of enforcement. As again, as Juan said earlier, if we would just say GSP is at risk and we mean it, we would have their attention full bore, and they would make a change in this dilatory tactics, as well as their injustices being meted out to left-behind parents. And again, there's always the issue of reciprocity. We do try in this country to honor our Hague Convention obligations, and that's to non-Hague countries as well. But our idea is that it is the rule of law. Custody needs to be determined at the place of habitual residence, not in some far-off court of law somewhere where a judge may not be Hague literate and not know the issues like parental alienation and the damage it does do to children. So we need, I think, perhaps to do a letter to the President, President Trump, and include your testimonies and some of the other very, very high-profile cases that make the case for robust and rigorous enforcement. And it also ought to go to Secretary Pompeo as well. I've raised it at the highest levels myself, but when you hear what you had to say here today, you can't help but be moved mightily to do far more, and hopefully the President will have that same view. Enforcement has been the problem since enactment, and it's time for that to change. The pivot day should be today. So if any of my distinguished panelists or any of you would, any final comments or okay. So thank you. We will work with you. It is bipartisan, I'm happy to say, and my hope is that your children will be home soon. God bless you.